get kicked off too. So the first one, we've got Chairman Barnett in the back here, his reentry courts bill. Senator Barnett, you are recognized to explain your bill.
Thank you, Mr. Chairman. To the members of this committee, and most of you all also serve on Corrections Committee, and had the opportunity to hear from Judge Prentice Harrell down in Senator Fillingham District when he came and talked about how important this bill was and what they plan on doing with this. But this bill came out of conversations and suggestions from both MDOC Commissioner Mr. Burrow Kane and several judges who thought that it would be good if we put in place mechanisms to work with some of the criminal justice reform that we've been doing. And this bill basically will allow certain individuals to enter into a drug diversion court, but prior to being incarcerated. So they've given a sentence, and in the bill it reads that a sentence no more than 20 years, then these individuals can participate in this program. And after this program is completed, then they will get time served, and there will be no prison time served for these individuals, because they realize that there's a lot of individuals who are incarcerated with drug charges and drug offenses that don't necessarily need to be inside the Department of Corrections. And that's just a simple explanation of the bill, and I'm open for any questions, Mr. Chair.
All right, questions for Chairman Barnett? Any questions? Yes, Senator Turner Ford.
Thank you, Mr. Chairman. Senator Barnett, does this bill in any way address those individuals who are incarcerated and do or hope to be released?
This particular bill does not, Senator, but there's another Senate bill that's passed out of committee and will be discussed on the floor that addresses the question that you just asked.
Is there, does this bill differ or give additional authority that the circuit courts do not currently have?
Can you repeat that question, please?
I understand that there are some pre-trial diversion programs that individuals can go through, and I think that falls under circuit court jurisdiction. Is this some additional authority that the circuit courts do not currently have?
Yes, ma'am, and what this bill does as well, Senator, it would be, this is a brand new rollout, and this mirrors some language and some legislation that was done in Louisiana, and it worked well. And this one would roll out, I think it would be 4 locations across the state where these courts would be implemented. And what the trial judges did, the judges did was they looked at the caseloads across the state. Mr. Chairman, you're welcome to intervene if you want. But they looked at the caseloads across the state, and then so they decided that the 1st district, the 7th district, the 15th district, and there was one more that would establish these courts. And then once everyone gets to see how successful they are, then the plan is to establish them in the other areas. But also with this one is that there is no money being asked for to be able to do this.
And you mentioned, is it perhaps maybe the 16th Circuit Court District that would be included?
I'm not sure if it's the 16th.
1st, 7th, and 15th.
First, it has the 1st, 7th, and the 15th, but I think Judge Harrell told me there was another one. I can't remember what that particular one was.
Well, I would like you to consider the 16th if the bill goes forward.
Yes, ma'am.
Thank
you. Yes, ma'am. Any other questions?
Senator Wiggins.
Thank you, Mr. Chairman. And this question may be for the chairman, and it's going more towards the practical side with the judges. Looking at lines 67 to 69, if they're eligible, the defendant shall waive the right to a trial and shall enter a guilty plea charge to the stipulation. And then going over to 73, the court shall suspend the remainder of his or her sentence and place him on probation. So does that, as I read it, that means it looks like it's working similar to what is what we used to know as the RID program. They would sentence them to RID, and then after they completed the program, they would come back, and then the judge would place them on there. Is that what we're trying to do?
It is, but the difference in this one is, since with the RED program, then they had to.
I'm not talking. That's just how I don't.
That's kind of similar, but that's what I was saying. But the difference is these individuals have the opportunity to be at home and this type of thing during the day versus being inside a facility. So it gives the individual a lot more responsibility to prove to the courts that they are willing to complete this program. And like you said at the end, there is that once they complete this, then their sentence. They would be, I guess, it would be like time served once they complete this program.
Well, okay, so okay. So they're not eligible for non-adjudication or anything after that. They're not, when they complete their sentence, they're put on probation. Is that right?
That's right.
Okay. And so, in practically speaking, when they enter their plea, then they'll be sentenced to Department of Corrections. Department of Corrections will handle that for however long, and then they'll come back before the judge, which then the judge will then place them on probation. Is that what you're saying? Okay. All right. Thank you.
Senator Simmons.
Thank you, Mr. Chairman. Just one or two questions, Senator Barnett. How does this program differ from the pretrial or diversion programs and or the intervention courts that we already have in place for pretrial detainees?
I think the difference is on this one, Senator, when you got an individual that has a drug problem and stuff, is that this individual may be sentenced, has already been sentenced. So before this individual actually goes and serves time in the Department of Corrections, is that then they will work with these courts and say, okay, then we'll give you an opportunity to go through this program instead of finding yourself in the Department of Corrections. So these are individuals that has been convicted. And when you talk about pretrial, then we know that there was an individual that not necessarily have gone through all of the court stuff. So this one here is, I guess, it's kind of getting those individuals after they've been convicted, but before they are to serve time in the Department of Corrections. And like I said, this was something that Commissioner Kane and the judges had talked about and thought that it would be a good model here in Mississippi.
And I know the administrative officer courts right now are involved in the funding of our intervention courts, which we used to call drug courts, but we changed the name to intervention courts. And when I look at lines starting at the end of 22 through 24, it says any person placed in the reentry court shall be counted in determining funding allocations to the court from AOC. And so are we sure there will be no funding that's required in order to implement the program effectively?
No, so there is no money to be required.
And I guess my last question, do we have a concern? Like when I think about reentry, I'm thinking about people who are already in the system, and we are trying to figure out a way so that once they exit the system, they can be productive citizens, and we don't have to worry about them actually coming back into the system. But it seems the way that this bill is written, especially when I start looking at lines 32, where it actually enumerates the criteria, and I start seeing even start at subsection C at line 39, the defendant is not sentenced to a term to exceed 20 years. The defendant shall not have any prior felony convictions for any offenses defined as a sex offense. The crime should not be a crime of violence on line 45, according to section 9732. These are some of the same requirements. I know you're not an attorney. I know you don't practice criminal defense, Senator Barnett, but these are some of the same requirements that would allow a person to be considered by a DA and or his or her attorney for non-adjudication, which means they don't even go into the system, and also for intervention courts. So I guess my question is, even in the areas that we are treating as the pilots, the 5th, the 7th, and the 15th, will this in some kind of way, are we concerned? My question is, are we concerned that they won't be pushed into the system when just to see how this program works, as opposed to trying to keep them out of the system and to use the tools we already have to help them out of the system?
So I understand your question, but what this bill does is it's what you're talking about from a trial lawyer, maybe step number one.
Okay.
When they're in the Department of Corrections, we consider that step number 3. This bill will actually be like a step number 2. You've been convicted, so that's when the commissioner and the judges, there'll be some conversations and said, okay, so before we actually send this individual to parchment, then we want to give this individual an opportunity to correct themselves before they've been sentenced, but there'll be no time that this individual, if they agree to these things and meet all the conditions, then these people that we're talking about would not have to go into the Department of Corrections. And so, and then again, when you talked about reentry, then we have to also think that reentry is not just for those individuals that have been incarcerated. So we want to try and make sure that they have the opportunity that they can re-enter society even before they get to the Department of Corrections.
Thank you, Senator Barnett. Thank you, Mr. Chairman.
All right, Senator Sparks.
Thank you, Mr. Chairman. Chairman Barnett, I think Chairman Wiggins hit the nail on the head. This is very similar to the RID program. There are requirements, and the big difference that I understand, Chairman Barnett, is that the 3 districts that are chosen are some of the highest volume districts that are operating intervention courts already. Those courts have an appropriation, but they also generate money from fees from participants. So they have come to the plate and said, we can manage this without a new appropriation. So it is a pilot program as it relates to that. But as it relates to RID, if I'm sentenced, and it is a difference between non-adjudication, it is somebody who would be going to prison, but they are put into a program, a work study, or not a work study, but a skills development type program, but it's incarceration. And if they successfully complete that program, again, RID was separately housed, I think at Leaksville, you were segregated from the population. And that's my understanding, is that they're going to have to successfully complete that program. Then they come back before the judge. Then they're placed into a reentry court, just like drug court. Drug court comes on the front end, intervention court comes on the front end. Reentry court would come from a time of incarceration of which there was workforce development and training. And if you successfully completed that program, you then go back before the judge, who's going to sentence you to probation, but very well may be under his or her guidance and supervision as it is intervention court. So it is keeping someone out of just a general sentence in the prison, but they are in the program, which is inside MDOC custody, then to be released into the supervision of the judges who are doing the reentry court. Is that kind of capturing it, Senator Barnett, that's the process?
Thank you, Senator Spark. Yes.
All right, Senator Thompson.
Thank you, Mr. Chairman. Thank you, Senator Barnett. I have a question specifically to lines 66 down through 71. I have some concerns about the defendant waiving the right to trial and entering a guilty plea. If I understood your explanation earlier, step 1 was the trial, step 3 was the trial, step 3 was the sentencing, and this was step 2 to be somewhere in the middle to give this defendant an alternative to incarceration, which I can appreciate. Why, and maybe some of our friends who practice, who have a criminal law practice can help me. Why are we waiving the right to trial there if they've already been tried and are being sentenced?
Senator Wiggins, I think, can answer that.
That's standard language because this is a plea. And so when you stand before the judge and do a plea, part of your plea agreement that actually ends up getting signed is that you're waiving your right to trial, you're waiving your Fifth Amendment, you're waiving your right to cross-examination, you're waiving all that right. So this isn't available, if I understand it, if you just elect to go to trial, which is totally your choice. This is a plea, and that's similar to drug court. When you stand up and do drug court, you're waiving your right to trial, you're entering a plea, the judge accepts your plea, and then he sentences you to drug court.
So there are
So
no due process concerns.
no, because it's voluntary and knowing, and usually, you have counsel and all that.
Okay.
So that's more or less, I certainly understand that, but that's more or less terms of art that has to be done if you want to accept this offer from the state.
Good question, good explanation. I think Senator DeBar had a question, okay, earlier. Anybody else? Good discussion. All right, Senator Hill.
When I'm looking at the short title, and it talks about it's on the second conviction, with some of the legislation passed in the last couple of years, this could be a common nucleus.
We can't hear you, Senator Hill. I'm sorry.
Okay, in the past, we've passed some of these bills to allow felony to be a common nucleus of things that would have in the past constituted several felonies. So I guess my question is, we're now saying that burglary of a dwelling is not listed as a violent offense if this passes. So it could be a common nucleus of felonies on the second offense, and they could choose this workforce program. Am I correct?
Senator Barnett, do you have an answer for that?
I think if you're looking at Senator, you would see that the individual cannot have more than one offense.
But in the past, we've defined to where felonies considered to be one could be a common nucleus of felonies. So that language, I would think, would transfer over to this, would it not?
I don't think it does, Senator, but I will do my best to find out and get you an answer on that. But I don't think that this bill speaks to that.
I don't know, maybe council can answer that.
From what I'm familiar with, that language is in the non-adjudication statutes, and I don't think that would just be pulled automatically into this program, but I can confirm that.
Thank you.
Awesome. All right, Senator Jackson.
Thank you, Mr. Chairman. I know it's been a lot of work put into this bill, and we pass bills year in and year out. What about the people that's already incarcerated? Would it fit them too, or just the one that's coming in?
Senator Barnett.
Senator Jackson, I think maybe Senator Turner Ford had asked that question prior to you coming. And this bill, like I said, it does not address those individuals already inside the Department of Corrections. But there's another Senate bill out there that addresses your question, that we can give those individuals the help that they need as well.
Thank you, Mr. Chairman.
No problem. Good question. Senator Simmons, did you have a question? Okay. All right, go ahead.
I was just going to say, as the bill moves through the process, and I understand we have a omnibus parole eligibility bill, and I think it does something from a more comprehensive standpoint. And I really appreciate all the work the Chairman Barnett has done on that bill. But if as this bill moves, if we can consider still identifying people that meet the requirements of this bill already in the system. I'm not saying the people who do not meet the requirements, but the people that meet the requirements of this bill, that are nonviolent, that are not sex offenders, that we can consider how do we help them also participate in a workforce rehabilitative program. I think that'll be great as the bill continues to move. Thank you.
Agreed. All right. I think those are all the questions. Senator Barnett, for your motion.
Title efficient do pass, Mr. Chairman.
All right. Title efficient do pass. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. Thank you so much. We appreciate it. Next bill is going to be a committee substitute for 2107 that was passed out just a few minutes ago. If you didn't get a copy, please let us know and we'll get you a committee substitute. And this is Chairman DeBar's bill. We're going to let him explain it.
Thank you, Mr. Chairman. As Mr. Chairman said, 2107, the committee sub was just passed out by Pat this morning, so if you don't have it, let her know, let us know. Committee sub for 2107 is basically an extension of and a strengthening of our state firearms preemptions law. And basically it prohibits a county or municipality from entering into any contract or rental agreement that restricts the possession, carrying, transportation, sale, transfer, or ownership of firearms. Provides for a remedy of that. But going through the bill, going through section 1, you can see on line 16, it talks about no county or municipality may adopt an ordinance or enter into any contract or real rental agreement that restricts the possession, carrying, transportation, sale, etc. Going through it, we add a new paragraph 3, starting on line 26, dealing with state agencies. No state agency may adopt a written notice, rule, regulation, etc., that restricts the ownership, possession, or ammunition or components. Line 31, paragraph B, no state agency or officers may offer or employees may participate in any program which individuals are given a thing of value provided by another individual or entity in exchange for surrendering a firearm to the state agency, kind of like the gun buyback programs. Paragraph 4, line 36, talks about the remedies for a violation of this statute. A citizen person licensed to carry a concealed pistol or revolver under this section, or licensed to carry a revolver or pistol with the enhancement who was adversely affected by this may file suit for declarative or injunctive relief against the state agency or agency head or member of the state agency's governing body in circuit court. Venue shall be where the violation occurs, not in Hinds County, but where the violation occurs. If the circuit court finds that, on line 47, if the circuit court finds the agency violated this rule, the court shall issue a permanent injunction against the agency, prohibiting it from enforcing the notice, rule, etc. And the penalty shall be that they can be civilly liable and a sum not to exceed $1,000 plus all reasonable attorney's fees, costs incurred in bringing the party to the suits. Public funds may not be used to defend or reimburse officials who are found by the court to have violated this section. 59, line 59, paragraph C, it shall be an affirmative defense to any claim brought against the agency head or member of the governing body that the state official did not vote in the affirmative for or support or adopt the written notice, rule, regulation, order, and attempted to take recorded action to rescind the written notice, rule, regulation, order, policy. Again, line 68, paragraph 5 talks about the exemptions from this statute. That would be paragraph A, line 69, state law enforcement agencies who regulate the carrying, possession, transportation, or sale of weapons. Line 74 is the Commission on Wildlife. Line 79, paragraph C, we're talking about our courts, Supreme Court, and other courts established by statute. Line 84, we're talking about state agencies, which under Article 8, Section 213A, which are the State Board of Education, Superintendent District, School Districts, and IHL. Line 88 is we're exempting community and junior colleges. Line 92, we're specifically stating we're excluding public schools to include districts, charter schools, agricultural high schools, school for deaf and blind, school for the arts, and school for math and science. Provided those schools and districts have adopted rules and regulations which comply with all state and federal laws. Section 2 on line 98 basically conforms this new statute to apply to all county and municipalities regarding the remedies and so forth. and that goes all the way to the end. And then in section 3, you can see this is there is a reverse repealer in this. So I know there is a House companion bill that is differing from this, but I expect it to go to conference at some point. But with that explanation, I'll yield for any questions, Mr. Chairman.
Hey, Senator Hill had a question.
Yeah, in the current enhanced, we're talking about enhanced concealed? Or are we talking about?
Yes, this applies carry and enhanced.
Okay, under the current enhanced concealed, a person cannot be prevented from carrying on school property, whether they have a policy or not. So in reading from lines 84 down through 95, it looks to me like this is giving them more authority against a enhanced concealed carry holder than what the law already has. It looks to me like it is rolling back enhanced concealed carry rights on public school property if they so choose to create a policy, because right now there is no provision for them to create a policy to keep an enhanced concealed carry holder from being at a ball game or on school property unless they're maybe an employee or a student. So I'm extremely concerned because we had a bill came through the Senate a couple of years back that would have done similar things for any type of high school or regular school activity. So my concern is this is opening the door to allow places who could not create a policy to keep enhanced concealed carry holders out to now be able to create a policy. So am I correct, counsel?
Let's ask Senator Barr first.
Well, I think if you
He
look
has
at
an answer.
96, Senator Hill, that says they have to adopt rules and regulations which comply with the state and federal laws already in place. So they can't create a new rule, regulation that violates state law. This just creates an exemption for them so long as it does not violate law currently in place.
Well, I think when you give them this opportunity to write, why are we giving them the opportunity to write a policy when now it's very clear that enhanced concealed carry holders have the authority to be on those premises?
We're giving them an opportunity to write a policy so they can state what the policy is so everyone knows what it is. That way, if it's clear what a violation that policy would be.
Couldn't they do that now without this?
They could write a policy so long as it conforms to state law, yes.
So why do we need this language?
We need the language so that if we have people on record that says that, and board members that have voted in affirmative or negative, so that if there is a violation of that policy, we can hold them accountable in the circuit court.
Aren't we just opening up for litigation when we're putting this section in here about a policy?
We're only opening up litigation for those who violate the policy or rules.
Well, we have a state law, so why do they need a policy?
This is a school board policy that states we are complying with federal law, or federal and state law. They're not supposed to create a policy that violates state law.
Well, it may come to the point to where federal law does not comply with state law. So why would we put this in there to give the opportunity for somebody from the feds to basically take over our firearms policy in the state of Mississippi in one of these institutions?
I don't think that's the reality. I don't think federal law is going to take over state law in regards to firearms in Mississippi. This actually strengthens the preemption laws to prevent the federal government from taking over our firearms laws.
I don't see that when it says has adopted related rules and regulations which comply with all applicable state and federal laws. We don't know what the feds are going to interact. So why are we giving the green light to an institution to say that you can put a policy out there that complies with federal law when we don't know what the federal, we already know that there's movement underfoot to roll back our Second Amendment rights federally. So I'm very concerned about this language within creating a policy.
Well, that's why it says state laws, and I would disagree with your conclusion that it basically restricts our ability or the school's ability or enhances the school's ability to restrict firearm laws. As you can see, that says they have to adopt the rules, regulations which comply with all state and federal laws. So I would disagree with your conclusion.
I don't see the point throwing that federal law in there So I'm not,
But we'll have Ethan look into it, make sure there's no issues. That does have a reverse repealer. And if there is a question on that, Senator Hill, we will definitely look at it and change it out on the floor if we have to.
well, that's my concern, because I don't want to open the door to allow somebody to regulate our enhanced concealed carry policy that would be contrary to what state law provides for that enhanced concealed carry holder. That is my concern.
All right. Thank you for that, Senator Thompson.
Thank you, Mr. Chairman. Thank you, Senator DeBar. I have a technical amendment at the appropriate times.
Go ahead and state it.
On line 241, just to correct the reverse repealer so that it shall stand repealed on June 30, 2021, sir.
June 30, 2021 instead of 2020. All right. Any questions of the author of the amendment on that cleanup language? If not, you've heard the amendment. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you, Senator Thompson. All right, Senator England, Vice Chair.
Sorry.
Thank you, Mr. Chairman. Senator Barr, I think this is a good bill, and I think the intent behind it is good. I do just have a concern, and I'm not opposed to the bill, so I want to just mention that. And this is just something that I think maybe we can talk about before we get out to the floor on this issue. With that being said, a couple of weeks ago there was an issue where there was going to be an armed march in the Capitol, and that didn't bother me that we were going to have armed people at the Capitol. What bothered me was that people were promoting that they were going to be armed at the Capitol. And being pro Second Amendment and pro gun rights, it concerned me that we had people that were maybe saw that as a way to intimidate when they walked onto the Capitol. Maybe we would take them more seriously. I never got a reason for why they wanted to have an armed march or why they felt they needed to have an armed march on the Capitol. It's their right to do so, but that concerned me. And with that in mind, my concern is if we have, and let me ask it as a question here, if the Department of Human Services denied an individual SNAP benefits under any laws that we present going forward, where we try to make sure that we tighten that organization up. If an individual is denied SNAP benefits under this bill, would the Department of Human Services not be able to tell someone that, yes, you can go see your social worker, and yes, you are allowed to carry your gun when you go see your social worker? Would that be the case under this bill?
I'm not sure the setup or the way the offices are, but no state agency would be allowed to restrict the use of the lawful carrying of a concealed weapon, especially with the enhanced.
Okay, and I understand that we have laws in this state that set out how to get an enhanced carry permit, but I did just have that concern, and I look forward to discussing that with you. I'm going to vote in favor because I do like the intention of the bill, but I did have that concern going forward. Thank you, Senator DeBar.
Thank you for the question. Senator Simmons.
Thank you, Mr. Chairman. My question goes to whether or not, as this bill moves through the process, is it sufficient that we have declaratory and injunctive relief? What's the rationale behind holding the state agency head or member civilly liable?
It's my understanding there have been issues in the past where agencies, whether it be county, city, or state agencies, have posted rules and regulations or policies that were contrary to our state law. And despite the fact that they know what the state law is, they post these policies anyways. And this is just a remedy, a way of putting teeth to the law that says if you do violate it and you knowingly violate it, that there will be sanctions for you. And that, because at this point, there is no sanction for any agency or body that does knowingly violate the law. And this just allows for some type of enforcement mechanism.
But Senator Barr, you will agree that based upon what is proposed here, declaratory and injunctive relief is also a relief in that if it's ordered by a court, then the agency head certainly should follow the court. And so you're just saying that that's still not sufficient, that still we need, or you believe, in addition to declaratory or injunctive relief, the actual agency head should be civically liable.
Or the person or persons that voted in favor of this rule, policy, or whatever, yes. This just should give them pause as to creating policies or rules that are basically prohibit a lawful carrying of weapon when they should be able to do so.
And I guess as a follow-up to Senator England's question, in light of the threats that we had and everyone being involved, whether it was the governor's office, whether it was Department of Public Safety, DFA, the leaders in this building, if they felt the need to try to protect the people in this building or members during the period of time where we were under potential imminent threat, then this would apply to those officials as well.
Section 5 basically exempts state law enforcement agencies in the performance of their duties.
But the leaders in this building are not law enforcement agents. And if they felt the need to say, well, in light of the threats that we are hearing, we want to try to protect, even for a short period of time, because they're not law enforcement agents, this bill would apply to them.
Well, DFA controls basically entry and exits of the building, and they are not law enforcement, but if they have specific intelligence would lead them to believe that an imminent threat is credible. That may be one thing, but frankly, I don't have a problem knowing that people are armed in the Capitol. I want to know if you are armed or not, because I know if you're armed, I know where the weapons are in case there is a threat. And so if people are here and they're armed, so be it. If they want to show it and they have a lawful permit to carry, then that's their right to do so. And of all places, the Capitol, where we make laws to allow for freedoms, then we should allow them to exert their freedoms here as well.
But based off how the bill is written, if Senator Kirby overrules and or a member of rules, if the 5 members of rules, one voted in favor of this, the other one's voting against it, those members who voted against what is being proposed here, they could be civilly liable according to how this drafted.
Anybody who basically violates the statute.
And Lieutenant Governor Holzman and or Speaker Gunn, if they felt that it was the appropriate thing to do and they posted a sign to try to protect the members in both chambers, then this bill, they'll be subjected to the language in this bill.
The exemptions are clearly listed in the statute.
Thank you, Senator Barr. Thank you, Mr. Chairman.
Thank you. Senator Hill.
The spirit of the bill is basically, should be to protect enhanced concealed carry holders and for them to have that affirmative defense and have some way to get injunctive relief. My concern is, again, where it says on line 68, number 5, this section does not apply to law enforcement, wildlife with their jobs. It already says in the law that a court in session, you can't take a firearm in with enhanced concealed carry. So I can understand why C's in there, because it already excludes the court when it says when a court's in session. So I guess now they'll be able to say whether it's in session or not, they can establish a policy. And then you're listing these other state agencies. What state agencies listed in Article 8, Section 213A of the Mississippi Constitution?
If I may answer, Mr. Chairman.
Yes,
Yes.
you're recognized.
That'd be State Board of Education, talks about superintendents and school district, of a school district, and talks about IHL.
Okay, so we're excluding all them from us having an affirmative defense to our enhanced concealed carry. and then you go down to community colleges, and then you go down to public schools. So why are we excluding these certain institutions, and what's left after we exclude these?
What's left is everything that's not listed here. And so we're excluding them because they need these policies in place. We already have, I think, AG opinions previously, and it's clear what is and what is not allowable. And this just clearly states out what exemptions are there.
I don't see any exemptions in the enhanced concealed carry law as it reads now, based on my memory. Other than a court in session, a jail, a brothel. I'm trying to remember, what else does it exclude, counsel? Not much else. Court in session.
Yeah, I don't think there are that many exemptions on it.
So I'm just concerned as to why we're putting more exclusions in here when we're dealing with enhanced concealed carry than what the law already states.
Okay. Thank you for that. And going back to Senator Simmons' point a minute ago, I don't think the leadership of the legislature would be deemed a state agency. It's a separate branch of government, so that would, in my opinion, not be subject to being personally liable for anything like that. All right. Other questions, comments? If not, for motion, Senator DeBar on your committee substitute.
Thank you, Mr. Chairman. Title sufficient, do pass committee sub as amended. Is that right?
Committee sub. Committee sub is sufficient. All right, you've heard the motion. All in favor say aye.
Aye.
Any opposed, nay?
No.
Okay, I think the ayes have it. All right, call for a division. Let's, and I think Senator McDaniel is on the Zoom meeting with us. So okay. So our secretary stepped out. He's back in. We're fixing to count. So Senator McDaniel, if you're tuning in and want to vote, you may need to unmute your Zoom and be able to vote with us. All right. So raise your hand if you are in favor of the motion, which is the committee substitute passage. Title official to pass committee sub. Raise your hand. All right. All right. Senator McDaniel, are you with us? I can't hear you. All right. You may have to unmute if you want to vote. All right. Those opposed, raise your hand. All right. The ayes have it. Thank you for that. All right. House Committee Bass Committee substitute has carried. Next bill is Senator Sojourner. Are you with us? I think on your Zoom, if you can unmute your bill is next, 2565. Senator Sojourner, can you hear us? I'm not hearing you. If you want to unmute and join us. Otherwise, I'm going to ask our counsel, Mr. Samsel, if he will briefly discuss this 2565. Senator Sojourner, can you hear us? There she is. She can hear us. Perfect. Senator Sojourner, you're recognized for 2565. If you'll get to one of these microphones. Sorry about that. You look great. All right. 2565.
Perfect. Thank you, Mr. Chairman.
Thanks for joining. Sorry about that.
So I've been listening to the other discussion. I promise this one is really short and simple. All the bill does is allows for, once someone has a concealed carry permit, that they can simply renew it online. The bill has the support of the commission. I spoke with the commissioner, and that's all the bill does.
And so you're not currently able to do this online?
No, you're not. And they're actually, the commission is working on doing this for other permits and things that they do as well through other bills.
And the benefit of this would be to lessen the number of people trying to get things done at the driver's license renewal stations and.
Exactly. And we have a lot of elderly concealed carry permit. They're older that were just susceptible to COVID, who were afraid to have to go in go through all the
Sure.
processes that we're required to do via paper.
All right.
And so the commission agrees that just doing this online is a simple.
All right. Any questions for the
Sojourner oxygen?
Senator Polk can share some oxygen with you.
Clearly, I am out of shape. Okay.
Other questions? Senator Turner Ford.
Thank you, Mr. Chairman. What is the 1,000-foot view? If a person wants to renew their concealed carry permit after 5 years, what are they required to do currently?
So currently, they have to go in and get paperwork notarized. So they would have to go in and get paperwork notarized. They would have to, like one lady, I had a constituent that called. Her husband was trying to get his done. It required them to make copies, I think, of their driver's license and mail it in. They had to take the form and print the form and then go get the form notarized to take it in. And so they're really pretty simple processes, but they were just things that they were requiring to have to go into multiple facilities to do. The commission did mention that they were very supportive and were trying to work on ways to do away with the notary requirement once they had a concealed permit. Certainly you could not do this on your initial application because there are, the background checks, the fingerprints, the things that you would have to be in person to do.
So what efforts are made if a person applies for the concealed carry permit, background checks are performed initially? Is there any follow-up to check their background again?
Yes.
Okay,
Yes,
so how are we, if this is done online, are we circumventing that process?
No, ma'am. Once they fill the application out to renew online, the commission still has to go through the process to do the additional background check, to take the additional steps to make sure that person still qualifies to be a concealed carry permit holder.
So instead of these trips to the multiple facilities, these checks are performed online?
No, ma'am. They would be just like they would, even if you submitted your paperwork to the commission still has to go through the process to verify and validate that nothing's changed in your background or in your portfolio, so to speak.
And I would just, I guess the basis for my questions would be just that issue in particular, that something has not changed in a person's background and it goes undetected because we're using this expedited process. But you're saying that should not be a concern.
I've been assured that the commission will still go through all the same process to verify that the person is acceptable for a renewable in their concealed carry permit.
Thank you.
The only difference is instead of walking into the office and handing the paperwork in, you fill out the application online. They do their process and then they either renew it or they don't. If there's a problem, you may still have to come in to correct whatever the issue is. Is that correct?
That's correct. I mean, nothing changes with the process that the commission goes through to validate that you can carry the permit.
You simply don't have to come in
I
person.
mean, they can deny your renewal. They
Sure.
don't have to, just because you submit it online doesn't mean you're automatically accepted. Your renewal can be denied.
Is there a fee?
There is a fee and the commission is in the process of implementing software that would allow them to collect fees for all various forms of,
Should the fee not be in the bill?
I'm sorry?
Should the fee be in the bill?
I'm fine if you want to make an amendment to do that. The commission seemed to believe that it didn't have to happen. They thought because of existing statute, they had the ability to implement that just as an administrator, but I'm happy to put that in there.
I'm sure the fee is in the statutory provisions elsewhere for just a renewal. I'm not sure that they would change that fee for online. I don't have any knowledge
There
of
won't
that.
be a change in the fee. It's basically just the process by which the fee is acquired.
Right. So the fee would already be authorized.
So the fee is
This
already
is a new
stated.
process?
I'm sorry.
This would be a new process?
This would just be supplanting coming physically into the driver's license station to submit your paperwork. You're just submitting your paperwork online, but the fees will not be changed. You'll still have to pay the fee.
Would there not be any additional cost incurred to process these applications?
I spoke with Commissioner Tyndall, as I know Senator Sojourner did as well, and he assured me they were happy to do this. They were looking for ways to get more and more people out of the actual stations and out of line so that their members could help other people trying to get their driver's license and other things. But he did not raise any concerns about costs associated with it.
So he's doing it for free?
Well, no, you're still going to pay. You're still going to pay the fee. You're not going to get it for free.
It seems as though there would be some sort of additional cost associated with this, build out of software, personnel to process the application.
The conversation that I had as well was that that the commission was currently in negotiation looking for, what platform, software, things that they would use to accept online fees. It was also stated that, currently there is still, despite the efforts of the last legislative session, that they're still having massive backlogs at local driver's license places and at the district headquarters where they do concealed carry permit. So that if they could, even if they negotiate, and I don't want to speak for the commission, and I don't know if anyone's here, but even if there was a minimal fee, that was something the commission was looking at possibly absorbing, because it would still eliminate tremendous backlog and time and staffing at the driver's license and district locations. But he assured me that nothing would change as far as the process itself.
Thank you.
Thank you, Senator Jackson, and then Senator Simmons.
Answer my question. Do the agency have the power to change the fee without our permission?
No, Senator, they don't.
Thank you.
Senator Simmons.
Thank you, Mr. Chairman. I guess a follow-up to Senator Ford's question, are we just allowing the application for renewal to be done online, or are we allowing the entire process now to be done electronically? Which means all of the forms that you would have obtained from these various agencies, will they now be submitted electronically, or are you still required for those forms to be physically submitted to the agency, and the process will still be reviewed the same way?
Right. For the initial application with you have to do that in person via paperwork. Simply for the renewal, I was told that everything that they would need to submit for the renewal could be uploaded online. And then the commission is still responsible for going out and gathering additional information that they have to gather to decide if the permit holder should be renewed or not. So it doesn't change anything for the initial check.
But for the renewal now, the way we do it now, and a lot of this is because I just don't know.
Yeah.
So the way we do it now with the renewal, you would basically, the process is similar to what you do in the original application. And what this would do is, for renewals going forward, everything now will be electronically. Is that right or wrong?
Basically, to fill out the application for the renewal, that you can do that online. Now, as far as the background check and stuff like that, the agency's responsible for going out and getting that information. But there would not be any, and there's others in here who are very much more well-versed on the concealed carry permit process than I am. But it's my understanding that there is no sensitive or volatile, so to speak, information that the person would have to upload or can fail to upload. They just basically fill out the application, submit the cost, and then the agency's responsible for doing the sensitive part that determines if this person is suitable to continue to have an enhanced carry permit.
And just to the benefit of me, because I don't really understand it, I'm quite sure other members who may not be well versed in this whole process. I don't know, Mr. Chairman, if it's for Senator Sojourner or the Honorable Chair, but can I just get a copy of what all is required without anybody's personal information? I just like to see the forms.
Like an application, yeah.
Yeah, the application and all the reforms, so we can compare and contrast the original process versus a renewal process and how this bill will affect renewals going forward. Thank you.
We can get that for you. All right. Senator England for motion.
Title sufficient to pass.
You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Now I'm looking at the clock. We've got 4 minutes before we go into session, and we've got one more bill, which is a DUI bill, which is very important. So I think what we should probably do is probably recess subject to call the chair, because I just don't see any way in 3 minutes now we're going to be able to explain, ask and answer questions, and take a vote on this very important bill that Senator Parker has been working on for a while. So with that, we'll call on Senator Simmons for a motion. Recess subject to call.
Recess subject to call, Mr. Chairman.
All right, you've heard the motion. All in favor say aye. All right. Any opposed, nay? The ayes have it.